courthouse the other day in the hallway. You're singing "Oh Happy Day."
One word prayer. Justice, where are you?
Okay, just going over my voluminous notes here in my official Justice Served TV notepad there that I've put through the paces today. Michael Bryant here.
Linda Kenny Botten here. I'm told that I look like a billboard, by the way, by Michael Bryant.
Yes.
A billboard.
Let's see, what is that? What does it
Well,
say?
it says Balenciaga. I'm in the country and it's really cold. I didn't have any sweater except for the billboard sweater. I wish they paid me to be a billboard, but you know,
that's a Shishi brand there, as I recall.
I don't know about that, but anyhow, what I really would like is a Justice Served TV notepad to go along with the cup and the mug I don't have, to go along with the booklet I don't have any longer. That's what I would really like, Michael.
Where's your booklet? What happened to your booklet?
I used it all. Every single last bit of it. I have used every single page. It's been very much in use because you are the camera for Justice Served TV. You went into the courtroom today and you've been in the courtroom in Orlando. You've been in the courtroom in Atlanta. I have been holding down the fort.
Writing notes.
Right. Researching and dealing with Brian Kohberger today. But you are the important person because you're the one we want to hear from, because in New York, even though they can allow cameras in the courtroom, they do not.
Yeah, too bad. Kohberger, of course, we'll get to that. But I saw the hearing on the docket that there was going to be this motion to take the death penalty off the table. That's usually a loser, but I can't wait till we get to it so I can hear some of your expertise on, what the arguments look like and whether you think there's a shot of that happening. I don't think so. Anyway, so this morning I did a little update on the Daniel Penny case. Of course, it's underway in Lower Manhattan. It's 100 Center Street, Criminal Courts Building. He's accused in the death of Jordan Neely. He was the passenger on the F train on May 1st, 2023 that, depending on your perspective, either was just unruly, like a lot of passengers are, or was threatening. And the witnesses continue to mount for the prosecution. Today, the two I mentioned in the earlier update were, again, witnesses who were there, and one of them testified about. I won't go into too much detail. You can look it up. Look over to our videos that are already posted. It's there. But they were mostly helpful for the state. The one woman who was contradicting her grand jury testimony, that was a bit of a problem for the state because she made it sound so much worse. Basically, she was asked both in court and by the grand jury, "Do you think Mr. Penny was trying to hurt Jordan Neely?" Well, with the grand jury, she said, "No, I think he was trying to protect people." Okay. But in court today, she said, "Yes, I think he went too far." So that was clearly pointed out in cross-exam and minimized her testimony. Maybe on the whole, she was a push at best.
Michael, I just have to interrupt you because this is very important. Missy Mayhem says, "Y'all look great today." So let me just stop that right there because I know we're dealing with very serious things, but thank you very much. We appreciate it. Okay, Mr. Cameron.
And you are, you need to interrupt anyway. And I know you're not very good at that, but you need, and throw questions and stuff out because I'm just going to go through all of this stuff to kind of get the information out there. But if you want to create a dialogue,
well, the dialogue
is like to do that. Then
is that Missy Mayhem says I look fabulous. Unlike you, she doesn't think I look like a billboard.
I wasn't talking about you. I meant that scarf thing. Looks like a billboard. Okay, here was my favorite witness. He doesn't rise quite to the level of Lil Woody, but Johnny Grimma. Johnny Grimma is a 40-year-old guy, admits to being homeless for a period of time, was a handyman at times. He finally does have his own home, considers himself a homeless advocate, says he had a minor drinking problem at time. He had a bunch of misdemeanor arrests. Ultimately, on cross, we learned that one was an assault with a baseball bat that was pled down. It was a felony arrest that was ultimately pled down. But he was one of the eyewitnesses. He actually, if you look at any of the videos that have been shown, and we've shown him here before, you will see him at some point as part of that little group that is hovered around Jordan Neely before the cops got there. Okay. And remember, the sequence of events is Daniel Penny decides he has to restrain Jordan Neely because he thinks he's a threat to people on the subway, takes him down, and after a number of minutes, 6-ish, he lets him go. And at that point, Neely seems to be, at the very least, unconscious. So this guy comes along, and his affect was just so weird. I can't really recreate it. But his speech was very pressured, as they say in the mental health business. You know what that means? That's where I have pressured speech at times myself, where you can't let somebody finish, where you feel like you have to kind of jump in. Doesn't work that well in a courtroom. When you're having a Q&A and the court reporter's starting to, get tense because you're talking over one another. He also spoke in sort of a narrative fashion at times, which I'll get to in a few minutes because it led to some serious objection.
I do have a question.
Yes,
How
ma'am.
many witnesses were there before he got on the stand?
He was the third for the morning session.
Okay.
Yeah. Anyway, so he starts talking about what he did that day. He had just been on the train and was getting off to switch from the F train to the D train, and they make an announcement in the station, NYPD, you're needed in car number 1, something like that. So he's getting off. He goes, I'm off here anyway. He goes on down and he looks in and he gets there before the cops. And so he has some of the things he observed. I saw he wasn't moving, his eyes staring off. He didn't record it then. Interestingly, he felt that it wasn't the time to record something, that almost out of respect for what was happening to this man, to Jordan Neely. But he does take a still shot a little bit later. And he wanted to, and he was very clear about this, he wanted to capture his eyes staring off into the distance. And he says here, I've never seen a dead person before, so he couldn't really tell whether he was dead, but that made an impression on him, those eyes kind of staring off. He also said when he first came upon the scene that he doesn't know what's going on. He doesn't know who the aggressor is,
different
who's
car,
the victim,
right?
and so he felt intimidated himself, like he was a little afraid to do much, and so he left and then kind of went to the next door. If you look at where most subway cars have two doors, front and rear, and the body of Jordan Neely was kind of in between the two. So he went basically from the head of the victim to the feet of the victim, those two different doors. And he came back in and he approaches the victim, who again is unconscious. That's all he can tell. And he recommends that they roll him over on his side, because he's he's on his back.
George Floyd. He
Yeah,
sees the George Floyd on all the discussion about people being rolled over on the side after they've been in a chokehold.
So he doesn't attribute it to that. But I'm sure there was a lot of latent learning by people who followed that case that that's something that you would do. He had a different comparison. He said, let me make sure I wrote this down here. He said, let me find it here because it was very important. He said that he knew it was important that they roll over on their side. He said, I think that's the way Jimi Hendrix died. That was his reference was to Jimi Hendrix, who, of course, was drug overdose victim. Okay, so that's all he does at that point. And then he has a water bottle, and he takes it over, and he starts to reach to like dribble some water on Neely's forehead. In later testimony, he wasn't really sure why he did that, whether he thought it would just comfort him or arouse him. But he was stopped by Penny.
By Penny?
Penny said, stop. And he backed off. He never actually did pour some water on his forehead. So,
to me, that's the most important thing I've heard in terms of in the prosecution's case that is against Penny, that he stopped somebody from offering comfort, which would appear to offer comfort to Neely.
I would argue the opposite. And I would say that Penny's, who is this guy with the water bottle? Isn't it sort of prudent to say, don't touch him, to back off, don't do that? So it can be interpreted as he stopped somebody from helping. It can also be interpreted that he was keeping somebody who may have ill will or no knowledge and trying to do something. He didn't know what's in the bottle. Anyway, so I think it can be argued both ways, and I'm sure it will be. But this witness who was really allowed to get in some amazing commentary that he shouldn't have, and it became the subject after he left the stand. He said things like, this is a situation that often happens with abusers, when an abuser stops others from helping the abused. So he is, in his mind, likened this already to a situation in which Neely has been abused by Daniel Penny. and him offering assistance and stopped by, in his mind, the abuser, it makes perfect sense to him based on his experience.
Well, that's exactly how I felt when you just said it. I immediately felt that was not a good thing, that the abuser had stopped help.
And I would think it was noted by the jurors, and we can get into. I got a lot of notes about them.
Yeah, but, tell me how they looked at that point.
Well, they certainly noted that moment, because anybody would make note of that. Oh boy, the defendant stopped somebody from rendering help. As you take a step back, that's a very common perception. I think once they dig into it and they see this guy was a biased witness, and I'll tell you what the judge had to say about that as we get through his testimony a little bit. We talked about the victim being in a vegetative state. Thank you, doctor. I mean, he doesn't have the basis for those kinds of opinions. He could say, I didn't think he was breathing. He could say, I felt for a pulse. He did not, but he could say that. But you can't say somebody's in a vegetative state. Anyway, he did. Got away with that.
Except that we've all watched TV. We're a lot different peoples in terms of what we perceive now than what we were maybe 20 years ago.
Well, it's the term. You could say he wasn't moving. His eyes were closed. Those are all
eyes are staring into outer space, right?
That's all those. But vegetative state, that's a diagnosis of sorts. That's a term lay people don't use.
Was it an objection?
There was an objection, but the judge, I don't think he sustained any objections, and it really got worse. He talked about how he contacted the police a few days later because he left before the cops got there. After he was told to stop with his water, he left. But a few days later, he reached out to the police, and wanted to give them a statement. He said he contacted the police a few days later, quote, after Neely was murdered. That was his take on things. Obviously, there was an objection there and a move to strike, and it really wasn't. It was just, let's move on. Let's move on. That's how the judge handled this. Is Judge Wiley. He handled most everything. Let's just move on. During this playing of the body cam footage, again, this was, I'm sorry, not body cam footage. This was, they never identified the person who was actually recording this, but it was before any of the cops got there. And during the playing of this, Jordan Neely's dad was just, I'm on the left side of the courtroom, which is the only place they let the press. The right side is victim family members. There's also some, I think, the public over there as well. But his dad was over there, Jordan Neely's dad. And as people probably remember, his mom was, what a crazy story. His mom was murdered when he was 14.
Horrible.
Her body stuffed in a suitcase and thrown in the Hudson River.
Horrible.
Even weirder than that. And they finally did catch the guy, and he's been convicted of her murder. Interesting way they caught him. You know how they caught him? He gets this suitcase from somewhere in town, in the Bronx, I think. He takes it home. She's already apparently dead. Can't fit her in the suitcase. He tries. Takes the suitcase back to the store and exchanges it for a bigger one.
Only in New York.
Yeah.
Only in New York.
And so that one does the job. He dumps her body. They find his DNA on that first suitcase that was returned.
Wow.
So
wow. That's really, anyways, that's a crazy story.
So that's, that happens when you're 14,
That's
and he was 30 years old when this happened, when he was killed. So when he died. So,
well, he was killed in some way or another by something. So.
Yes, whether or not,
but
a murder or not. Yes.
Yeah, I was talking to my husband Michael, who knows a lot about chokeholds and teaches the state police and stuff like that. The reason why it doesn't recommend you do it because it's only like 10 seconds that you die, and you can't judge. You can't judge whether it's 7 seconds or 11 seconds. You just shouldn't do it. That's really, and that's why in Los Angeles they eliminated chokeholds, and the police in New York aren't supposed to do chokeholds either. Because you just can't have control over when the person is going to decease. And so does that in itself become excessive? So it'll be interesting to see what the state does in terms of who's trained in what, and what the training that Daniel Penny had was.
Yeah, and of course, as a Marine, that'll be an issue as well. And this whole vigilante narrative became the subject of the mistrial motion, which we'll get to. But anyway, so when this video is playing, Jordan Neely's dad is, he's hunched over. You kind of see his shoulders. He's upset. He's very emotional. He's there with the family attorney, They're really just the two of them together.
Yeah, it's Dante Mills, right? Isn't Dante Mills who we
it
knew
is.
from Law and Crime represents the family, right?
Yeah,
But, can I just make a comment here? Let's Go P said Penny knew the move could render death. So why don't you offer something that could save his life? And I think there's going to be that discussion in the jury. The person that won't give us an interview on camera, but spoke to me as a source because she had seen Neely so many times. She rode the same subway he rode a lot of times and all, and says that, it was 90 pounds soaking wet. The thing that got to her most was the fact that Penny didn't offer aid to Neely. That's the thing that stuck out to her. So it'll be interesting to see what the jury does and whether that's part of any of the charges.
And the time frame is very important too. We'll get to that in just a minute with another one of the witnesses. Anyway, so the judge between the first and second sessions this morning reminded the audience, the gallery, no outbursts, no emotional displays, and that's because during prior body cam footage, like one woman, kind of blurted something out and she had to take herself out of the courtroom. When Neely's dad was having this emotional reaction, it was quiet, I will say that. But later on, he did have an outburst, and we'll get to that when we get to when that happened. So anyway, that was the morning session. That was key. This particular witness, I think, was so biased. He was so biased that I wrote "so" with 5 O's. So defensive. He was just. You could just tell his mannerism was, I don't like you, Mr. Defense Attorney. You're representing scum, and I am not going to help you in any way.
I've had that happen to me when people are really don't like me. You're representing scum, and I'm not going to help you in any way. So I've seen that attitude. I mean, if you can't handle that as a defense attorney, you shouldn't be a defense attorney. But that's beside the point.
And he handled it pretty well. But it was.
I take my Dunkin' Donuts coffee as we're talking.
It was getting bad. So during the cross-examination, this witness, again, it was Mr. Grimma. He offered that, quote, Penny played with his dead body many times, end quote, quote, flinging his arms around, end quote. So it was just, we're seeing that, you see the video. I don't know that I would describe anything that was done as playing with the body or flinging the arms around. So, the jury can see this guy's putting his own overlay on stuff. And he did admit that he did nothing initially. He left the train before he returned. Then he says, I regret walking away when a man is getting murdered, end quote.
And that's where there was an objection, and the judge just said, let's move on.
That was the second time that he said that. Then there was a moment, this was interesting too. Remember, grand jury testimony had already been taken long before the led to the indictment. So a lot of these witnesses gave grand jury testimony. There's a moment when Penny takes the pulse of Jordan Neely, or at least is searching for one. And he apparently then nods, okay? Doesn't say anything, just nods. Right. So in court today, he was asked about that. And according to the witness today, he interpreted that nodding to be Penny saying, I effed up. Okay.
Oh, interesting.
Yeah. But in grand jury testimony, which was pointed out to him, he told the grand jury that nodding told him that shit was okay. Like,
two different opposites, right?
Totally opposite between the grand jury testimony and the testimony in front of the jury today. So clearly biased. There were a number of objections. There was a sidebar after they broke and after this witness left, mainly because of the narrative nature of the testimony and because of all of these, murder this, flipping the body around that. And here's what the judge said, Judge Wiley. He said he could tell the jury could see how biased this witness was. And his goal was to get him on and off the stand as quickly as possible. So
that's an interesting.
It gives you some insight into the judge. Yeah,
insight into the judge. But he didn't say that in front of the jury, obviously.
No. Jury was gone. This was all just before the break when there was some follow up. What he seems to do is he doesn't like sidebars.
Excuse me. Are you drinking out of the mug I don't have?
Well, same mug I use all the time. Yeah. But, and I should mention the last two that we sent out because of the Where in the World is Justice for the trial we're now covering. Those are already out in the post, as they say. So they should be, there'll be other people with mugs you don't have. So anyway, that took us into the break. Let me give you a little info on the jury if you want. The afternoon session was pretty lame. It was a lot of There's a 911 call, which was not good, and some other body cam footage. But the witnesses are pretty pro forma, but we'll get to those. So the jury, very interesting. They have 4 alternates. This is nobody would ever be able to decipher this. I'm not sure I can either. But here's how the jury is set up. There's 2 rows of 8.
It's more artwork.
This isn't. I don't even know what this is. More like hieroglyphics. So there's 2 rows of 8, and so I have them broken down. I have woman, Hispanic, or Indian, and I'm sorry, but sometimes I can't. I just can't tell. So I'm covering my bases. There's a couple of 70 plus women. One I love. She wears this fedora. And she's really dressed well. I'm thinking Upper East Side. I don't know how they draw from Manhattan for the juries. It's the whole island, I'm guessing, right?
Right.
Okay, so who knows where they're coming from, but they're very distinct looks based on parts of the island. Would you agree with that?
Yeah, absolutely.
Okay, so that's where I put her. And then there's some 20-somethings. There's one girl who's in the front, one woman who's in the front row. She's in her 20s. She is out of the courtroom quicker than anybody. Everybody, the jury gets up. By the way, in New York, they don't ask the gallery to stand up. In Florida, they do. California, they do. New York's like, we're not standing for the jury.
Neither New Jersey or other.
So they get up, and she is right behind the bailiff. And there's, everybody else is still barely getting out of their seats in the jury box. She is gone. I don't know if that's some indication she's checked out or not. I don't know,
but it's different because in Massachusetts, you just have to stay seated until the jury leaves. You don't get up. In New Jersey, they just don't ask.
Yeah, we stay seated. Yeah, we stay seated. We actually stayed seated until the defendant leaves and his entourage, which is not just the attorneys, but there are probably 12 law enforcement officers in this courtroom. I don't mean bailiffs.
Wow.
I mean NYPD, because there have been so many threats made against both sides.
Oh, wow.
And while we're talking about the jury, I'll throw this out there. They have been deemed to be anonymous. New York law says you can't be anonymous, that even if the public is not told who the jurors are, the parties know. Not this time. When the judge rules that they are going to be anonymous, nobody knows who they are.
We had that in Phil Spector. No one knew who they were.
I believe that's a California case. I don't know what the deal is.
Yeah, well, because of the concern of high-profile people contacting and all, we didn't even know who it was, and it's very hard to pick a jury when you don't know who the jury's coming up, because we all get our thing. Here's such and such.
Sure.
They're from Red Bank, New Jersey. I know Red Bank, New Jersey, so I can say what I think they're going to be like. Even though you're making these broad brush assumptions. And
we know stuff about them. We just don't know names.
Right.
Because, we went through that the other day, all the 12 jurors who what they do, we had 2 of them are attorneys. I couldn't pick them out. So they're undercover. Like me, nobody thinks I'm an attorney. So it's kind of undercover. Anyway, so all this is, as you sit there and you're watching this unfold from the very beginning, you as a trial attorney, you're thinking, okay, put that on my list of appellate grounds if there's a conviction. Because there have been cases overturned in New York where they've had an anonymous jury. And the theory is if the jury knows they're anonymous and they do it for their benefit, right? Mm-hmm. They may think that the defendant is somehow more dangerous.
Right.
Therefore, it prejudices that system against the defendant.
Sure, because where did the anonymous jurors come from? They came from the mob cases, the mafia cases, the John Gotti cases, where they were scared, and all. And that's exactly, they're scared to give anyone the names out. And that was always the argument. So that's it's now seeped into other cases. But boy, that was, that's where it came from, Michael. And you know that, and I know that. Don't go watch The Godfather with the horse head in the bed.
Yeah, that was good. That's good stuff. Okay, so we move into the afternoon. We had
the
Paul
horse
Williams.
Head in the bed was good stuff.
Oh, that movie
nightmares. It's like great. Wizard of Oz. I can't watch Wizard of Oz.
What's the name of that actor, John Cassavetes Sr., or I think that might be right. Who is John Cassavetes Sr.? That's my Jeopardy answer. I think that's right. Somebody correct me on that. Fact check that. Okay, so in the afternoon, we had Paula Williams, NYPD. She was just the administrator for 911 calls, just custodian of records to get that set up. So they played the 911 call. There were actually, and this is interesting, the timing on this is most important. There were four calls made, 226, 2 of them at 2:28, and this again is May 1st of 2023, and then 1 at 2:29. And they all come in with, varying versions of, is there a weapon? Is there not a weapon? We know there was not a weapon.
Right.
So we have, and then we have an officer who was on the scene, mostly for crowd control, but she gets there, Officer Vesey. The victim at the time was unconscious when she arrived. She talked to the defendant. He said he had heard Mr. Neely say, quote, "I don't care if I go to jail for life. I don't care if I die," end quote. So he tells this officer the same thing that most people have testified to having heard in one form or another. And he admits that he admits he put Neely in the chokehold. That was really about it. If in the video you can see Neely Jordan standing around. It's just, Daniel Penny standing around. And he's just chewing gum. Like he's near the scene when the cop comes along, and very nonchalant. Doesn't seem to be stressed, or I don't know. Maybe that's what he does when he's stressed, is chews gum. But he's just.
Well, I'll tell you what. In my opinion, he is going to have to take the stand, Michael.
And I think you're 100% right. Yes.
I think he has to take the stand, because I think that that the nonchalantness is, and now covered with this water bottle that just stops somebody from possibly giving comfort. If that's the way they interpret it, it may not be. That he's got to explain his actions as to why he did what he did, including that statement that if Jordan Neely made, that Jordan Neely statement sounds like it's against Jordan Neely himself. I don't care if I die. I don't care if I go to jail. I just don't care. I don't care about my life, is what it sounds like Neely is saying. Not that I don't care about your life.
That's interesting. If you listen to one of the witnesses today who described that rant as satanic, so it isn't so much like melancholy. Oh, I don't care if I die. It's like, I don't care if I die. I don't care if that's a very different way to hear those words. So, except
that when you're walking down the street of New York, and I've had this discussion because I live in New York City. I live right there in Midtown. You have people walking behind you like I'm ranting and raving, ranting and raving and ranting and raving and ranting. I mean, just constantly. And we have such and I'm going to say it again, we have such a mental health problem in this country, especially in the big cities. We don't have any place to put people, and they're all around us, and you don't go killing them.
I understand. Brooklyn Pesola, does that sound right? Pesola? Yeah, there's no doubt the train is the way to go. If you're in the city, if you can't walk, you take the subway. I don't even want to pay a car service because it's slow. It's slow. It's just slow.
Right. You took the subway to Center Street, right?
Of course, yeah.
Right.
I get on the 4 or the 5. It's just 2 stops: Grand Central, Union Square, and boom, you're there. Although sometimes those trains are much more packed because they are the express. You take the 6, and it's got about 8 stops, but you might get there sooner, just depending on because there are more 6 trains that come along.
Right.
Anyway, so much for that tour guide information you'll need when you come to Manhattan.
So who's up next?
Okay, so. Let me see if I finished. The officer, Vesey, who gets there and hears the statement from the defendant attributed to the victim. They gave Neely 2 doses of Narcan, which did not do anything. And she did not find a pulse, but admitted that others prior to her arrival did. So that's going to be key, okay?
Except that having a pulse, it's been explained to me, does not mean that you're not necessarily already brain dead, okay? You can be brain dead and having... Yeah, but for those of us listening to it, that's going to be a distinction I'm sure the prosecution is going to have to deal with, right?
No doubt about it. It just creates crevices for the defense, I think.
Okay.
Whether they were able to pry them open or not is another story. Okay, so the jury... I thought this was interesting. This is a human nature behavior thing, perhaps. So you got the jury, two chunks of 8, and big monitors, like maybe 75-inch, on the right side of the jury box and on the left side of the jury box.
Okay.
So human nature, you would think people would watch, somewhere in the middle, the 4 and 4 would watch this one, and the 4 and 4 would watch that. Interesting. Some people, 2 in from the other side, watching the one further away. And 2 people further away watching one that was like they're crossing vision. You know what I mean?
Right.
And so I don't know if that's because some people are more interested in detail, or maybe some people are more afraid of detail. Like they don't want to see up close what we're seeing. I just thought it was an interesting social experiment in human nature.
When they're doing that, are they able to see different parts of the courtroom? I mean, when they're crossing over, who can they see?
Yeah. Okay. If you're on, let's say you're in the, and I'll put myself in the jury box. I'm now looking into the well of the court. left side of the jury box, right side. If you're on the left side and you're looking this way, you're looking right at the witness and the judge.
Okay.
If you're on the right side and you're looking across, you're into the gallery. So
That's interesting.
If you're in the jury box looking left, you're in the gallery. If you're in the jury box looking right, it's into the well of the court, the witness, the judge.
So it may not be the detail. It may not be the detail or non-detail they're looking at. They may be looking at reactions
from people. It could be, yeah. But some people clearly look more intent on the imagery, the monitor. Just I noticed that. Another weird thing about this courtroom. Ever see a courtroom where the witness box, the witness stand, is even with the judge?
New York.
Usually it's. He or she is the king and queen. They're elevated, and the witness stand will be down a little bit. Nope. And they have some weird, funky steps. The judge has to say, "Watch your step, watch your step." One of the witnesses almost took a tumble today. So it's just weirdly set up, and the whole. One of the people I was talking to in the gallery said it has weird feng shui in this because I felt it was more tense in there than I've been in a lot of courtrooms. Partly it's the law enforcement presence. The case itself is, very volatile, but it just felt tense. And, maybe it's the feng shui, but it is a big, as I said before, big courtroom, 8 rows split, 1 on each side. Each one will hold 8 bodies. I haven't done the math, but figure that out. What would that be? That would be 16 times 8. And it's like 100 and some people, right?
That's a big courtroom.
And this is not like pews that you can sidle over next to your, they have the chunks of wood. That separate. This is your seat. This, they're rails. So
right.
It's pretty much decided there are going to be 8 people in that pew, and when they put you in, it's boom, boom, boom. It ain't, I'm spreading out with a seat on each side. No, you're in your chunk.
It's kind of that way when you're called to jury service at Center Street too. When you go in, you're brought into a big room and stuff like that. It's really fascinating. I mean, Center Street is a fascinating place to be. Either called to jury duty or serving jury duty. So.
And you go out, there's that kiosk out front that's for the jury to, it's greenish and blue for the jury to check in. It's just weird. And you go inside. I mean, I contrasted it with Orlando from a couple of weeks ago. Orlando's like going to a nice hotel. That's the courthouse like a nice. This is not a hotel I would want to stay in. This building, it's beat up. It's just beat up.
It's Center Streat. I mean, it's don't you watch Law and Order? Don't.
Yes.
Have you ever seen Law and Order?
Yes.
It's only been on for 47,000 million years.
It looks better on TV.
So that's really interesting. So what's the prosecution? How long is the case expected to take, and what's the prosecution got coming up?
Here we have, they aren't giving us the heads up on witnesses, unfortunately. But I think the way they're moving through, and to me, right or wrong, in my experience, when you run out of witnesses on a given day, it's because you're moving along maybe quicker than you expected. Yes, right or wrong to you?
Yeah, that's true.
Yeah. So I think they're moving along, and
but you think it's quicker?
The judge has suggested the jury might get the case. I think I X'd this out earlier. Might get the case by Thanksgiving, which is not good in my opinion, because either you're cramming it in to get it done before the holiday, or there's that 4-day period.
But if you're the defense, you're loving that.
You like them to have
loving that because you hate to get a guilt. Juries hate to give guilty verdicts before holidays, Thanksgiving, the standard holidays, the old-fashioned ones, Thanksgiving, Christmas, the old Easter type area, that type thing. They hate it. So you
would rather they cram it in and put this in the jury's hands with at least a day or so before the holiday?
If I'm a defense attorney, absolutely.
I think it's going to be so close. I think it's going to be, a situation where they have to maybe put off closings until Monday. And that's Monday's the December 2nd, because Thanksgiving is very late this year. It's the 28th.
Yeah.
So
that could happen.
Yeah. I just think
can I tell you a little secret about when you want to cancel your jury service for the first time when you get called, and they give you the time you get to pick in New York the second time you want to come? It's always preferable to say, when is Thanksgiving? Okay, I think I would like to come on the Tuesday. Okay. Or when is Christmas Eve? Let me see. I think I'd like to come on the day before Christmas. Always really preferable to put that in for your jury service.
Good idea. And two ways to get out of jury service. Not that you would want to, because it's a great thing to do.
No, I try to get on.
Oh, you want to? Well, who wants you on a jury? Are you kidding
No,
me?
they didn't. They didn't. As
Nobody.
a matter of fact, a great story is I tried Phil Spector. I came back. I had to put off my jury service because while I'm trying Spector in California. So I go. I'm right back. I have to go on the Monday. I'm back. I get all the way through, and I'm like so happy. I'm like, I'm going to maybe be on a jury. I was so excited. And then they start calling the witnesses' names. And guess what?
You know half of them.
My husband was a witness in the case, and they don't tell you which side they're on. And I'm like, Your Honor, Your Honor, I don't think I think you should take me. And finally, the bailiff came over and said, well, I don't really want to stay here and affect the jury because one of those witnesses, I don't know which side he's on, is my husband. And the judge said to me, I saw this come over here, and he said, you guess you don't know what your husband does? I said, no, as a matter of fact, I've been gone for 6 months. I just got back,
Yeah. That's so funny that you didn't talk about that at dinner. What's the deal?
Yeah, no, we didn't. It was like, so it was really funny. And I keep trying to get on. I can't get on. The next time I was there, do you know anybody, in the criminal defense system? Yeah. And as a matter of fact, the prosecutor that's on this case I have a case kind of against her, like right now, and then I know this, and a half an hour later, they said, I think you should just leave, go back to the big jury room. I'm never getting on a case.
Yeah. I've never even been summoned to jury duty. Is that weird? That is weird.
Yeah, it's weird because
Never
in New York,
even
you're like every 4 years now, and you're called 4 years.
Different states I've lived in, but still,
Never been summoned. Thank you, Missy. Thank you. A big fan. He's also got a new show. I talk about my husband, Michael.
Oh, yeah.
They keep repeating the HBO shows. He had 14 years of those, and he's got a new series on Fox Nation about crime. He doesn't get involved in politics, so let's not go there. About crime, crimes that are his cases he solved. The first 2 episodes have dropped, and they're working on the third one right now for it. And you can take a look at it, and you'd love it.
Nice.
Okay, I diverge.
That was good.
I diverge.
Okay, so let me get through this because I wasn't able to really follow Kohberger much today, so I want to.
Okay, then we're done. So Penny, that's it. So let's go through this because I want to hear Penny.
Okay, let me give you the up to the mistrial motion. Okay, so the timing that we talked about. Remember, there were a lot of the 911 calls, 226, 227. From body cam footage, we can see that the EMTs arrive at 2:47. They're going down the stairs. That's 21 minutes. From the first 911 call. I think that's going to be very important, that 21 minutes, if you're the defense especially, because maybe if he wasn't truly fatally or mortally wounded, that their arrival sooner might have made a difference. I mean, when the jury's starting to kind of go through all of this, who knows what they're going to focus on, but I think that's going to be an important 21 minutes. Okay, then there was another officer, Officer Ortiz. Here's interesting. This is very interesting. This guy was on the scene, but he was really there just to pick up the witness, in this case, Penny. So he's there to pick up Penny. You know what they say, see a penny, pick it up, all the day you'll have good luck. Well, he picks up the penny and he takes him back. I'm sorry, I apologize. He takes him back to the precinct and he has a partner with him, an Officer McKay. We learn later after the jury's dismissed that McKay is either not available or isn't going to testify. And here's why that's interesting. They get back to the precinct and they put Mr. Penny in a room, an interview room. He's there for more than an hour, okay, before anybody really even talks to him. But then McKay comes in and they're just chatting it up. And they're talking about, they both had military background. Obviously, Penny was in the Marines. And through this witness, even though there was a sidebar just before this happened, to keep it from happening, the witness talks about McKay, his partner, in the interview room with Penny, talking about military experience, and maybe Penny will be working for the NYPD someday, that he's thought about doing that. That's a problem. It fits the prosecution's vigilante narrative, right?
Right.
And it was talked about just before that question and answer elicited that information. So Kenneth goes crazy. It reminded me a lot of the YSL stuff where, you give the prosecution the benefit of the doubt up to a certain point. And he had already reached that point where he said, this was not inadvertent, Judge. They know what they were doing. We talked about it at sidebar. They were not to go near that to bring out this information. And he said on top of that, he's in there for an hour, and they had a pretrial hearing to try and get this information suppressed. He's in there for an hour, no Miranda warnings, having this friendly chat with McKay to soften him up, according to what the defense says, so that there would not be a Miranda issue. And then when they did issue the Miranda warnings, he'd be more amenable to talking because he was a chummy guy now with Officer McKay. All of that came out as part of the mistrial motion. And it was basically Kenneth saying, it started with the opening statements, Your Honor. That's when they started this narrative about racism, about vigilantism, about what the victim was wearing because he obviously was homeless. And I mean, all of that, he threw that all into this mistrial motion, which of course denied. But he made a very important point, I think. And, maybe the judge will be more aware of what the prosecution is attempting going forward, because we've seen it in YSL. If they're going to do it.
YSL was. We have a question about YSL. So as soon as you finish that, we'll
okay.
Segue into it.
I think I'm done. I think that's most of everything.
Well, before you do that, who's coming up next?
I don't know. They won't tell us. They
won't tell you.
No, they won't. It's still the prosecution's case. I sense that they've now transitioned from recipient witnesses to first responders, and so I'm assuming that there'll be a medical expert soon enough to talk about cause of death. I think that's where we're going. That's one thing about this case compared to others like YSL, which is the moon. This is a very finite, insular event, right? It happened very tight quarters, very tight time frame. So you can focus and hone in on that pretty easily. And I think they are. So that's where I think it's going.
Yeah. Yeah. Just, it's a horrible case no matter what. It's just a horrible case.
It is horrible.
I mean, I don't know what I'd do if I were on that jury. I said to someone today, it could easily be a not guilty, and then it could easily be a guilty. Remember, he's only charged with 2 counts: manslaughter, which is reckless, a reckless killing, or it could be criminal negligence, which is a culpable negligence, a really violent negligence. I mean, you have to really be negligent, like a big negligence, in the killing. So it's not murder. It's not a case of murder. And the penalties are substantially different. One is 15 years for the recklessness, and one is which you serve probably around 7 or 8, and one is 4 years, which you may never get out of Rikers. Which is it's kind of like being at Rice Street. If you follow the YSL case.
You're begging for state prison. Oh, one thing I forgot to mention, and this is important because I talked about the outburst that had happened. And
right, you forgot, right?
Yeah, there was a moment in the mistrial argument, again outside the presence of the jury, where Kenneth was talking about one of the statements that had been made describing Neely as, quote, an unhinged nut job, end quote. When he said that, Neely's dad blurted out something, and the judge had to quiet him down. Kenneth wasn't trying to upset him. He was just using the argument that that's part of the narrative that the prosecution's putting forth. That the vigilante was there to stop this unhinged nut job. So
it's going to be interesting because, again, I'm going to refer you all to use your Google on your phone. Look up the case of Bernard Goetz, Goetz. And I don't remember when it was. Was it in the 70s? What was it, in the 80s?
I think it was in the 80s.
Yeah, represented. He killed people in the subway system. He was afraid that the 3 men nearing him had guns. He killed one. I think a couple of them were injured severely. He was acquitted on the basis of his fear. The jury found reasonable. He had a great attorney at the time, who, by the way, never, after that, didn't practice criminal law, practice civil law, decided not to practice criminal law. It's Barry Slotkins, great attorney. But you can all Google it to see whether the same type of vibe, that whole issue of vibe being so important these days, is still around. So, Michael, you're heading back into the courtroom when?
I'm going to take tomorrow off. I'll be back in there on Monday. So
okay.
So we'll follow it tomorrow as well if there's many details, but I won't be sniffing around the courtroom tomorrow.
Okay. So you're our camera in the courtroom, and usually going into tomorrow, they may have one big witness leading into the, maybe it's the medical examiner leading into the weekend. As we know, it's theater, courtroom. Drama's theater. So while you're away, we have Brian Kohberger, but we do have a question because I said we'd segue by Michelle Corley. Can we show that, please? Thank you. Hello, y'all. Hi, Michelle. How are you? Did you hear about the expensive watch from Young Thug's house? I want to hear more. Yeah, it's been really interesting because remember that bag of jewelry. Supposedly it had a Richard Mille watch in it, and if you look that up, that's and
you have a couple of those, don't you? Have a couple of those?
Yeah. No, I don't. I don't have a couple of those. They're really expensive. But the hotel across the street from my office.
Check this out.
Do you have a?
This is a $40 Timex, baby.
Timex, and it's still running.
$40.
Yeah. And
Twisto Flex band.
Anyhow, the reason why I learned about it, I never knew about it. There was a robbery about, maybe around the beginning of the pandemic, maybe it was in the middle of the pandemic, at the Baccarat Hotel, which is like really an expensive hotel on 53rd Street, across from my office, right? And somebody had a Richard Mille watch worth $500,000 or something that was taken, or maybe two. And it was all over the New York papers. And unfortunately, the New York Post called the man's wife to get her reaction about her husband being robbed at the Baccarat. And it turns out he was robbed by some woman he had just met that night near the area. And I don't think that went over so well. So that's the first thing I learned about how expensive a Richard Mille watch was. The second thing is when I played in a legal poker game, one of these TV poker games, somebody was wearing one. And I thought, well, maybe I don't think I should push my chips against that, because I don't think money means
one of a few all-in pots.
So apparently it had that in there. It was ruffled around. Supposedly things were stolen. Supposedly things were taken. The state's seeking forfeiture of all that jewelry. But the question is as somebody brings out, as Michelle brings out, was a cop photographed actually trying it on? Not necessarily wearing it in court, but trying it on beforehand. So that's got all sorts of stuff. But
sounds like some prejudgment forfeiture, perhaps.
Maybe. So I think we all among yourselves there, talk to Michelle about this, because we all have different views about this. All I know is that one of the things they wanted Thug to give up was his right to contest any forfeiture, which I don't think at this point, when he was getting out, you're so dangerous, you can't be on bond, and then we're just going to let you out for time served because we have excuse this. This is going to be a legal term. Close your eyes if you were upset about this language. Fucked up this case, okay? Just say that to you. But us attorneys, everyone. So that's exactly what we think happened here. And by the way, Thug was on Brian Steele's iPhone. Brian Steele went to teach at Emory, right? And Thug gave a little bit of a lecture and said, you all should be defense attorneys, not prosecutors. The defense attorneys are very, very important. I rest my case. Okay.
So about the bag of goods, clearly it wasn't properly inventoried. All of those tools. It just was, if it's evidence, there was no evidence that it was properly treated as evidence.
Right.
Each thing
or where the things are.
Everything should have been bagged, and there should be an inventory somewhere. And anyway.
Now, what if you say that the cop may have been wearing it on the stand? I didn't see that, but if
I mean, I've seen some dumb things, but that would be probably a little bit beyond.
This is YSL, and we're going to be talking more about YSL because I know they had a day off today. Tomorrow they're going to have jury instructions. We're going to see if we can get Doug back on. He's lead counsel right now, the two that are left, so it's kind of hard. He's a little bit busy. Or get Ashley Merchant on tomorrow night, and if we can, we will have another show tomorrow night. Probably around 6 o'clock.
I'm sending him a text right now. Just
please send him a text and send Ashley a text because we want to know what's going on here, because the prosecution said they're going to rest within the next 2 weeks. Gee, this case that was supposed to take 2 more years, now 2 weeks they're going to rest.
Funny how that happened.
And it's going to be finished by Christmas, says the judge. So we want to see what the inside scoop is. If we can't really get the inside scoop, but yes, we can. We can figure it out. We can glean it because we're all trial watchers and we're great. And yes, we're going to be following that. And given what's happened, I see you all say and Fonnie Willis got reelected. Yes, she got reelected.
Yay. What a shocker.
And she got reelected. And S, let's go P. Thank you for being our camera. Michael, that is you. You are our camera in the courtroom.
I'm telling you, we're weird about trial stuff. We're all these true crime junkies, but it just feels so cool to be in the courtroom. If I'm not trying the case, at least, it just feels like home. Does that sound weird? It just feels
it's
you know,
wonderful.
to be, in that environment.
But the
I
one
love it.
courtroom you wouldn't want to be in is the Brian Kohberger case. So let's transition to that.
Ah, okay.
Yeah. While you were doing that, I was working and listening to the Brian Kohberger case. And what was interesting about that is that there were motions concerning the death penalty here. Remember, this case was transferred from the one small county, Later County, to Ada County. Now, Ada County may sound usual for you because it's had some big trials lately. Here's a test, Michael. What case?
Well, other than the Lori Vallow Daybell
There
case
you
or
go.
Chad Daybell case, I don't know.
Yeah.
I'm sure there were others.
And there's a lot of others.
It's Boise, Idaho.
Yeah, this judge that's had the case, Judge Hippler's, has had a lot. I was shocked how many murder cases he's had, high-profile murder cases, and serious, evil, horrible murder cases, right? That he's had. And I always thought, Idaho, come smell the beautiful fresh air. It's safe. It's wonderful. And I was reading this stuff today, and I'm like, I'm never going to Idaho to live. That's for sure. So here are the motions. There was a motion in Chambers. I don't know how it came out, but I'm assuming I do know how it came out. And it was in Chambers, which I think is really, I don't know why, at 8:30 this morning, their time. And you said to tell everybody that there's 2 time zones in Idaho, right?
This one is 2 hours behind East Coast. So it's mountain time.
All right. So whether or not Brian Kohberger can wear regular street clothes to all the hearings, not just to the trial, all the hearings. I do that automatically with all my clients. So if they're to have them wear regular street clothes, and it's always granted. It's always granted. You have to bring the clothes. I mean, as the attorney, you have to meet up with the sheriff's. It's a lot of work because you go to the sheriff's office in the morning every single time that you're dropping off clothes. They have to inspect it, make sure there's no contraband in the clothes, blah, 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 blah. Plus, usually as an attorney, a lot of times you're stuck buying the clothes that your client is wearing, unless you have access to his family who can give you clothes and all that kind of stuff. So I don't know what the situation is here. He was in street clothes today. I did see there was a lot of people watching who were objecting to it, but that's the norm, that you don't put somebody in the orange jumpsuit when they're in hearings. It's prejudicial, right? And all. So we'll find out at the next hearing what happened there, I assume. All right. So the prosecution had some other things they filed under seal with the judge, and the judge ordered them at the end of the day to be not under seal. The main thing was a PowerPoint by a law professor dealing with the issue of the death penalty. And so what could it be dealt with? Well, the first argument was, is there a violation here because Brian Kohberger had to sign away his right to a speedy trial, which he did last August, I think 21st, right? So that he could defend this case. And what they argued today is that there's like a Sophie's choice. Either you have ineffective assistance of counsel, or you can have a speedy trial, because you can't if you're going to have a death penalty case, you really can't do it within 6 months, which is the requirement for a speedy trial. Speedy trial is a constitutional right. The 6 months is a legal right that's set by each state, right? So you really can't have both, because you can't get ready for a death penalty case in 6 months. You just can't. Although there was a case called Lori Vallow Daybell, who did ask for a speedy trial, right? And the state wasn't ready after 6 months, and then they couldn't go after her for the death penalty of the death of the 2 children. So, and that's Ada County. So that was the argument. The judge at some point said, this is really falling flat on me. I don't think, you signed away your rights. That was the right you had the right to have a speedy trial, or you could have said, no speedy trial, which is what you did. And here we are. So you can't now argue ineffective assistance of counsel, because you're being effectively assisted by your counsel right now, who's preparing for the death penalty. So that was the first argument as to why there should be no death penalty. The judge, by the way, is going to issue written rulings. But we know where he's headed on that. Next, why there shouldn't be no death penalty. Well, 8th Amendment, it's cruel and unusual. And this is where everyone files motions, cruel and unusual, because you're supposed to be able to inject to kill somebody in Idaho. And if you can't do that reasonably, then it goes to the firing squad. So the whole issue of injection is whether or not there is a conscious pain and suffering. And it started out by states using midazolam. And there was a difference of opinion about whether or not midazolam actually put you out, or whether midazolam still made you conscious enough, like when you're in the hospital and you used to give them midazolam instead of Versed, to feel the pain and suffering. Now, what's happened is states can't get midazolam because the companies aren't giving it. They don't want their drug being associated with the death penalty. So that went to like argument. That was like a cruel and unusual argument A, right? It went to argue, and that's what the PowerPoint apparently is about. Then it went to argument B. Well, we don't think it should be firing squad because no one has ever legitimized firing squad as being not cruel and unusual. That kind of fell flat on the judge. I mean, there wasn't too much about that. Then it went to like argument C, that we're moving away from the death penalty in the United States. Only 27 states have it. Many states are moving away from it. And if they're not moving away from it, they're having a pause in the death penalty. They're like in California and Hawaii, they're pausing it. There is a map. I actually did print out the map for you, state by state. You can look it up. I said facetiously, it almost looks like a voting map from the other night. Yeah, but that was facetious because it really is an important issue. But 27 states still have it. And the reason why there's a pause, according to the prosecutors, the states cannot get the drugs to do the lethal injection. So you had the A, the B, and the C argument with regard to that. And the judge wasn't buying the fact that we're moving away from it because it's just a pause. Even federally, it was a pause under this administration. I assume that when the next administration goes in, they'll fire back up again. Yeah, but maybe not with the firing squad, which is what Idaho has, which is like Utah. It is really. Well, I can't imagine being in the firing squad. So then they went to an argument, and I'm summarizing this for you. We could spend a whole hour on this, and maybe we will eventually. They went to an argument that the aggravating factors, which have to be proven under constitutional law to get the death penalty, were actually, they said you could drive a Mack truck through them. They're so broad that almost any single crime could be a death penalty case, and therefore it's not specific enough. And what they focused on was specifically, there's 11 aggravating factors in Idaho, right? But they focused on one of the last ones, and it said the defendant by his conduct, whether such conduct was before, during, or after the commission of the murder at hand, has exhibited a propensity to commit murder, which will probably constitute a continuing threat to society. And they said, well, how do you define propensity? How are we going to have a hearing on propensity on that? And therefore, these aggravating factors are vague. And you could say if you've committed one murder, everyone has a propensity to commit another murder. And so that's kind of like was the last argument on whether or not the death penalty was a violative of the Eighth Amendment for being cruel and unusual, or whether the aggravating factors were violative of the Constitution for under due process rights. And then we went back to the issue of whether or not you could have an aggravating factor hearing, or whether or not the defense wanted it to be trifurcated. I've never heard about a trifurcated. What they want is not just, they want a separate hearing on aggravating factors dealing with this whole issue, especially of propensity, which is one of the ones that's being charged. And then you would have the issue of the mitigating factors, and whether the mitigating factors are such that they outweigh the aggravating factors under Idaho law. And that's kind of where we end. The judge said he'll issue a written ruling soon. I think he's going to deny all of this because the trifurcation has been unheard of. And as he's going out, and he says, and by the way, that actually the defense said, you said that the PowerPoint we filed today under seal in your chambers this morning probably shouldn't have been. He said to unseal it. So I haven't seen it. It was done by some professor at a university, probably having to do with the conscious pain and suffering. So here we go. Here was the headline: Brian Kohberger to fight death penalty at hearing in Boise. That's what happened this morning. I assume that we're going to hear that these are all going to be denied sometime by the judge.
If I had my gavel, I'd put it away. I would be gaveling that and denied. So
well, that's as succinct as I could make it for you because it was a long hearing.
Yes. What is it, 140 some pages? Something like that?
148 pages, I think.
So some of those arguments are lovely for appeal. And then the analysis of aggravating mitigating factors, if I'm the court, I'm going to say, well, yeah, we'll get into all of that.
Right.
If there's a guilty verdict and we go into a sentencing phase, then we'll get into all of that stuff. But right now, I can't deal with that pre-trial.
Well, let me tell you that if you look at the law, which is, I printed it out for you specifically with the history of the law and the law, their aggravating factors are pretty broad, okay, in Idaho. But that was one of the ones that is really, really broad. I mean, then you have the standard ones. The murder was heinous, atrocious, or cruel, manifesting exceptional depravity. Well,
Yeah.
well, you know it. It's kind of like, the Supreme Court used to say
Obscenity.
Obscenity, right? They know it when they see
You know
it,
when you see
right? You know what it is. Kohberger, if he's guilty, and I'm just going to say if, because it's only alleged, and he has a right to be presumed innocent. These homicides are right there. All right, and we haven't even heard the medical aspects yet.
And
I mean, remember that dripping blood.
There are two tracks for those arguments. One would be through the legislature. Okay, you want to fine tune the legislature and the language, do it. Propose that new legislation that better describes these conditions. That's one way. The other is through appeal. But neither way is a trial court decision. They're just not going to do it. So.
Yeah, it's all. So we had a full day here at Justice Served TV with Michael Bryant, leaving very early this morning, being in the courtroom all day, going back to Connecticut, getting ready for the show. We have some previous videos that we did show the unfortunate death of Mr. Neely. And then some of YSL, we'll try to do another show on that. And of course, Kohberger, and we'll try to do a longer show on that as maybe when the judge's opinion come down, breaking it down, because that's kind of a lot packing in a very short time. But I know you all got it.
And when is the trial is on the calendar now for? Is it April or is it June or July?
No, it's next year in August. I thought it was
in the summer.
It was supposed to be during June of. They were going to sandwich it in between the school university being in session, which was kind of ridiculous. Also because Ethan's siblings still live at least right now, still live in the sorority house, not the sorority, the fraternity houses across the street. Fraternity sorority houses across the street. Just incredible. But thank you all. Yes, Madeira Beach Caregiver, bookmark your questions for the next show, or send them to. Give us your email, Michael.
What is the email? We got a few different ones, but I think
9/11/25. Dizzy says is scheduled for 9/11/25.
9/11. Okay, so it's like right after school gets back in.
All right.
I think
what's your email?
I think the best one probably is MJB Bryant and Bodden at Gmail. MJB Bryant and Bodden at Gmail.
Oh, he proved you wrong, Madeira Beach Caregiver. We're an open book. We want you. We absolutely want you to send your questions so that we have them next time.
Yeah, I know she did put something up there that we're kind of drifted away from, but we'll get it. We'll get it next time.
Yeah, we will. But thank you very much. Michael, you have some words of advice for tonight?
Oh, I suppose. I'm Michael Bryant. Try to do the right thing.
And I'm Linda Kenny Bodden. Please subscribe, like, share, and notify. We are Justice Served TV. See you.